Hi, hello. Welcome to this webinar on force majeure and COVID-19 coronavirus. My name is Carl Haynes and I'm going to be moderating this webinar for us today. And alongside me, you should be able to see here my colleagues Karen Sherrill and John Fotherby, who will be mostly leading the discussions and questions and responding to some of the polls that we get. And also in the background is my colleague Wayne Edmonds, who will be doing the driving of this webinar for me. And so I'm briefly going to call on Wayne to bring up our first poll, which should be just an inquiry for all of you out there to find out which part of the supply chain you are from. I could ask you all individually, but there's 86 of you, so that might take some time in getting around. Just to give you a bit more understanding about what we're going to be doing today on this webinar. The duration of the webinar is going to be 45 minutes, and we should be on the nose with that. And then, so following this introduction, we're going to have around about 25 minutes worth of discussion with Karen and John, talking around key topics. And also we're hoping at the end of this discussions to get some legal perspective from a representative of Atkin Chambers, who's joining us on the webinar, Nicholas Bartz QC. So hopefully we'll be hearing from Nicholas a bit later on in the webinar and hearing his views. And so we'd also be having 15 minutes at the end, hopefully around about 15 minutes at the end of the webinar, so we can have some questions. So you may notice on your control panels that you have the option to post questions to us. So that's not the chat bar, it's the questions bar. So any questions you get during the course of this webinar, please type those up and we'll try and field as many of those as we can at the end. You know, there is a large number, and so there's a good chance we won't get to field all of those questions. And with those questions, we'll respond to those after the webinar. And then finally, I just want to point out that, you know, this is not meant to be a claims management seminar. The purpose of this webinar is to have a high-level discussion around some of the key issues which you're going to be experiencing and which are affecting the construction projects as a result of coronavirus. Okay, so you can see the results of the first poll there. So a large number of contractors, but we've got representatives from owners, vendors, and service providers. So without any further ado, I'd like to just quickly send up the second poll as I introduce John Fotherby, which is what percentage of your projects are being affected by the COVID-19 pandemic at the moment? And perhaps while we're waiting for the results to come through on this, John, I might ask you to just start, maybe share some of your rationale for this webinar, please.
Yes, thank you, Carl. Well, good afternoon, everybody. Yes, I'd like to start with just some scene setting. I think we all recognise that we're facing unprecedented circumstances, and that these circumstances really affect the construction engineering industry globally. The impacts are pretty serious, or the potential impacts for owners, contractors, supply chain, service providers, almost everybody that's involved in the industry are likely to be affected. And the situation is complex and constantly changing. So we're really in uncharted territory as we look at the situation today. So the effects are likely to be delayed projects, certainly additional costs, impacts on cash flow, and even possibly some company failures. If we want to achieve lasting solutions in the short to medium term, then this is only likely to be achieved by taking a collaborative approach. There's two issues to address, really, in my view. The first is a need to mitigate the impact of this situation with coronavirus. And secondly, to recognise that at some stage this will pass with either recommencing projects or continuing with them, and but certainly always on a different basis to how we originally saw the projects going. I don't think anybody's going to escape from this cost-free. And I think the real issue is, in this context, is what does it look like from the owners, the contractors, the supply chain, etc. perspectives. And those perspectives are likely to be influenced in the first instance by, am I buying or am I selling? Because from a buyer's point of view, force majeure looks as a good means of dealing with it. But from the seller's point of view, it isn't, because typically, as we will be discussing later, there's no financial compensation. And I think it's essential to recognise those differences in positioning and overcome them, because it's going to be a means to finding solutions that work for everybody, which I think is fundamental in this situation. Now, compliance with the relevant contractual provisions, force majeure clause, if there is one, is important to support any case that wants to be made for a claim for relief. However, I think reliance entirely on legal and contractual arguments alone is unlikely to provide effective solutions to the challenges that are confronting the industry and the projects being undertaken in the industry. Therefore, pragmatism in the face of adversity that provides solutions that respect all project stakeholders and favour none in particular is what is probably going to be the most workable way forward. This webinar considers only force majeure, and we're going to look at the pros and cons and the relevance and what needs to be done in face of force majeure as a starting point. Legal concepts to be considered that might also support a case for some relief. For example, frustration, change in law, impossibility, etc. However, none of these concepts are easy to deal with. They all have their challenges, and they're all quite similar to the challenges that face us with proving force majeure. So that's a bit of background. I think we're going to move into having some more detailed discussion now.
Yeah, Wayne, I don't think I saw the results of that poll. Thank you. Okay, so there's a rather large amount of people being affected by COVID-19, or projects being affected by COVID-19. So, okay, so before we move on to the next part of this, I just want to put another question out to you again, and yeah, 132 of you now, so this should be quite interesting. Here's a question for you. So, coronavirus, COVID-19, is it force majeure? Yes or no? So we're just gonna give you a few moments just to place your vote on that before I hand this across to Karen. So your choices are yes, no, or not sure. So it'd be interesting to see where we fall on this. But maybe just as we're waiting for those results to come through, and as they do, Wayne, maybe just bring them up. I'd like to put this to Karen then. Karen, help us out. Is this event force majeure?
Well, I think we're going to see that the answer to that is probably it depends. It depends on a whole load of different things, and that's what we're going to sort of start discussing now. And thinking about what those basic questions are and where we might go with that. John, do you? Oh, here's the. So we've got a view here that most people, 77% think it is force majeure. Okay. Well, let's try and address that comment and see whether you've got the same conclusion at the end of this discussion as you have at the beginning. So, so John, let's go back to some basics and think about why do some contracts contain force majeure clauses?
Yeah, good question, Karen. I think it's fairly safe to say that most international engineering contain a force majeure clause. I can't think of any that I've dealt with over the years that don't. But why are they there? So I think we need to think about events and circumstances that occur on projects that are the responsibility of neither the owner nor the contractor, or contractor and subcontractor, or whatever the relationship is. And therefore, if those events and circumstances occur, then the party that is suffering from them would probably be said to have taken the risk on those, unless there's a force majeure clause there. So if there's a case where prevention of a contractual performance is as a result of force majeure, then the party is not liable. And that's the basic reason for force majeure being present.
And what are the common 4 components, 3 or 4 components that qualify for force majeure? Well, so is this event in itself a force majeure?
I mean, I think that the 4 that come out of, and I've got to say, the force majeure clauses are often quite different, as I think we'll see just a bit later. But first of all, I think unforeseeability at the time of entering into the contract is the cornerstone. And then that the events are not preventable and are not under the control of the contract, and that those events actually prevent performance of a contractual obligation. So I think those are the basics, no matter how they're wrapped up in the language of the contract. That's what those are the criteria basically for force majeure.
And as I think many of you on the call will also know that all force majeure clauses are not the same. You know, they're written in very different ways, from a very general definition of, you know, an exceptional event or circumstance. Sometimes it's done with an exhaustive list, sometimes it's an inexhaustive list, written in lots and lots of different ways. So they do vary a huge amount, even within, you know, lots of the standard contract, like you know, FIDIC compared to NEC or JCT. So you really do need to read your definition in your contract as to be clear as to what it says and what those conditions are. And the other thing to note is that this concept varies very widely depending on which jurisdiction your project is, or many jurisdictions if you're doing international projects. So there's a big difference between common law jurisdictions, where the courts have got a very much more hands-off approach to it, and that the parties agreed to whatever risk at the beginning, and that's written into the contract, and the courts will tend to interpret what's written in the contract, versus the civil code countries, so like France and like many places in the Middle East, where, you know, it's been enshrined in the civil code. So in France, it's been enshrined in the civil code since the 1800s, and but now has an actual definition in the French code, which includes tests of foreseeability and avoidance of the impacts of that. So again, you've got to look at the contract, but you've also got to look at the jurisdiction, the underlying law. And as I say, if you've got a whole supply chain, you could have many countries involved in that. So again, this is why we're going to conclude that it depends is an answer. So so with that background, we've got many force majeure clauses relate to also have the right to suspend or terminate after so many days of force majeure. John, what's your opinion on that?
Well, I think there's 2 things to take into account. First of all, does the force majeure clause in the contract actually allow for the parties to terminate the contract? And that will be then clear. You know, it might be 160 days of continuous force majeure event, or whatever the period is. And even if it doesn't say that, then I think you've got to look at the governing law, because some seem to me to provide for termination after a certain period. And I think this again depends on how the governing law treats force majeure as an entity. And as you mentioned, there's some quite wide variances across the world in different countries.
Okay.
I think the other issue is, of course, where there seems to be quite a bit of confusion, given the questions that we've been asked just recently, as to what there is compensation, financial compensation for force majeure events. And I think the answer is probably that generally there isn't, unless on one hand the contract actually says so. And I can think of some force majeure clauses in subsea contracts, for instance, where financial compensation is provided for. But if it's not stated in the contract, then I think you have to turn to the governing law to see how that force majeure, because there may be some regulations there that allow for compensation. But I think the starting point is to believe you will get extensions of time, but you won't get money.
And certainly we've got a vast majority of contractors on this call, and the questions that we're being inundated from them is, how are the impacts of this crisis going to be financed? Because the parties suffering largely are the contractors and the supply chain below that. So if we were to go back to that original question, John, then do we think it qualifies as force majeure?
I'm not going to say, as the lawyers say, it depends, but it definitely does.
Yes, yeah.
I think that we have to start from basics in this situation, and the first question to ask is, what contractual obligation cannot be performed, and what is preventing it? Now, whether you're an owner or a contractor or a subcontractor, anybody, this is the question to ask first off. And if the genuine answer to that question is coronavirus, the next thing to consider is, well, is there a force majeure clause, and what does it say? And if that clause exists and contains words around epidemics, etc., or is very widely crafted to include anything and everything, then it's probably safe to assume that there is a provision there on the basis of force majeure for something like coronavirus. And assuming that the contract was signed before this coronavirus occurred, then the probability is that that will be a genuine force majeure situation as a principle, and that it wasn't under the control or preventing contracting parties. Then we come to the question, how was the contractual performance prevented by coronavirus? And this is the tricky bit. And I think it's best to illustrate this by, first of all, we've got to bear in mind that we have to recognise that we cannot have a great deal of remoteness between cause and effect. There's got to be a linkage. But if we take, for example, a manufacturer of a piece of equipment, and it closed its workshop because the workforce was depleted, isolating, they're off ill, or they were forced to close because of government regulation or something, but it's all linked to coronavirus. And therefore they were unable to deliver the equipment by a specific date required by their purchase order, then that would probably qualify as force majeure, providing the other conditions relating to it were satisfied. But if we then look at the intended recipient of that equipment, and if that recipient asserts force majeure due to late delivery of the equipment, then unless that recipient can demonstrate that they didn't receive the equipment on time because of the closure of the workshop coronavirus, then his case for force majeure may not succeed. So again, it's about the facts and linking to the original cause of the event. Now, all that sounds nice and easy, because it's one purchase order. But as we know on projects,
it's a bit more complicated.
Thousands of purchase orders. So is when you ask the question about what's preventing performance as a contractor, say, in front of an owner, then you've got to really segregate out those purchase orders, for example, that are actually affected by coronavirus, and you've got that cause and effect link back to the original cause. And just to conclude on that point, I think that a generic assertion that coronavirus in China is force majeure on a project in the Middle is unlikely to fly. Because it may be a fact that coronavirus is present in China, but did it actually affect an area where a factory is? And did it close that factory? And did it prevent the delivery of equipment, etc., etc.? So I think everything is fact-based before we can even start to think about what does the contract say, and what are the legal implications of this?
Yeah. And I think because of that, you know, one of the key messages that we want you to take away from this webinar is keep records. You know, you must keep detailed records of what's going on, because it will come down to what you can demonstrate, and you're going to need some facts, documents, and evidence to be able to do that. So that's sort of one area. So I mean, at the moment, you know, I mean, even since last week when we did this first webinar, there are increasing regions of the world that are going into lockdown, and entire countries. So is the fact that a country is in lockdown in itself force majeure? We've seen some guidance from our UK government, even yesterday, which we might put it politely, is grey. Would you not say, John?
Yes, grey is a word that I would use, but this is a public meeting, so I'll stick with
we'll
grey.
keep the expletives down. Yes.
Yeah, definitely. I think that, and I'd like to know other people's views on this, but and around the world, there's great evidence in the way that this epidemic is being treated. But there does seem to be an avoidance of any admission that it is a problem of force majeure or anything like that. From a governmental point of view, wise, but not helpful.
Yeah.
So I think that the way to respond to the coronavirus is another issue that overlays the situation that needs some thinking about and some unraveling, because it does cast doubt as to whether this qualifies as force majeure or not. And again, we have to go back to the contract, the governing law, to see what they say in each jurisdiction, because I think it, as you mentioned earlier, it does vary.
So, Karen, then, you just alluded to records during that last bit of the discussion. So I wonder if you might want to speak about, you know, if we think this is coronavirus, if we think it is force majeure, sorry, you know, what do we need to do? And you mentioned records. Perhaps there are some other things there that you want to bring to light.
Yeah, well, records is absolutely essential. So, you know, document what's happening, and also think who's got those records, because it might be that your subcontractors, your vendors have got those records, not just you. And you're going to need to demonstrate that. So the other areas, things that you need to do is serving notice. So please serve notice, and the party that's actually prevented from performing its obligations, from doing its work, is the one that needs to serve notice. Doesn't matter whether your client, whether anybody in your supply chain doesn't recognize that. Serve notice in compliance with the contractual provisions. And then bear in mind that eventually you will be required to prove the impact, the actual impact that that this event has had on your project. And let's be real about this. And if your project is already in delay, was already suffering events before this, please don't use this as a nice excuse to wrap and cover up all of the other areas maybe of non-performance, because that's going to really prove very, very difficult. So you have to, eventually there will be however this thing is resolved, whether it's done by a formal claim process, a negotiated settlement, and going to court, there's going to need to be a force majeure claim put together, and it really will help you a lot if you put it together in conformity with the contract. Document the costs as well. Document all the costs, because hopefully, as we want to try and illustrate, is we really would, that we would prefer to go down a negotiated, equitable settlement route. And in that case, if you are able to secure some money, then again you're going to need some evidence for what that is. So in terms of other things, John, what else do we think we need to be aware of?
Well, I think, and this goes back to some questions that we've received already about what constitutes force majeure. And we've had a couple of questions about owners preventing contractors from entering the site, but without the owner saying force majeure, it's due to coronavirus or whatever. And therefore, I think in those circumstances, we're not looking at force majeure, without the owner dealing with this appropriately in accordance with the contract, then we've probably got a breach of contract situation, because the owner is preventing the contractor from entering the site. And, you know, depending what the contract says about entry to the site and possession and everything, that looks like a breach of contract. It's an entirely different claim. So I think this goes to the need to look at the facts and get them very clear from the outset, because the way in which force majeure works is quite different to other clauses in a way, and how you deal with it and what can be recovered. So I think back to again as well, people taking their responsibilities under the contract and dealing with them. So if you're the owner and you're prevented from, because of regulations, or you can't get your people to site, or whatever the situation is that's directly related to coronavirus, then you should to serve notice of that force majeure event. Doesn't stop the contractor from doing it, but you are the party that can't meet your contractual obligations, and therefore you should deal with it. So it's everybody in the supply chain that needs to look at this. It's just not down to contractors to say this is force majeure or not force majeure. And I think there's an issue which goes to your point of records, which you have to prove that, you know, this is coronavirus is force majeure, basically, as we've talked about previously. But more importantly, the impact, and this is the difficult bit. It's going to be really quite difficult to demonstrate the actual effect, but it will have to be done if people want to make a case. And together to be able to hold a discussion about commercial solutions if that's going to be on the table. I don't think there's any point in just complaining about the situation and trying to make assertions and hope that someone's going to settle with you just because you're great people. People have to be accountable for whatever they agree to, and this is going to be the problem of establishing the reasons and helping the other side to help you find a solution.
Okay. Guys, I just want to move you along a little bit. But before I do move you along, this last part was about, what else do we need to know? And I'm just interested, Wayne, if we can bring up the next poll, please. And I'm really interested to know what else you out there would like to know with regard to COVID-19 and how it's affecting your projects. So if I could just ask you to just put down your thoughts on that on this poll, and in the meantime, Karen, while we're getting those responses in, perhaps you might just quickly wrap up then, what else do we need to be aware of with regard to everything you're talking about here?
Okay, so a few points. Force majeure or the coronavirus does not supervene, existing delays and costs. It follows on from them, and therefore you're going to have to distinguish between the coronavirus and other issues rather than just putting them all into one cloudy issue. Don't attempt to use force majeure as an excuse for pre-existing delays. I've spoken about that before. That applies to everybody through the supply chain. Don't try and fit coronavirus into a force majeure clause if it doesn't fit. If it doesn't meet the criteria. There will be other legal remedies, contractual remedies that you can use. So don't try and force fit something where it doesn't work. Use it to potentially enable an adult, mature conversation with the contracting parties, with the aim of finding an equitable solution. At the end of the day, everybody wants these projects finished, and there's a certain point along this path when contractors, for example, may be entitled to terminate the contract, which presumably is not the win-win solution that everybody's after. So there is a point at which we're going to have to sit down at the table and talk about this, how we're going to rebaseline the project, get it started again. And this is really about really not trying, for whichever part of the supply chain you're in, not trying to exploit the situation. This is about doing, it sounds naff, but doing the right thing to get the project, put the project first, so the interests of that. And that means that probably everybody in the supply chain is going to lose a bit of money, but it shouldn't all fall to one party. That's not equitable, and force majeure, however it's done, is supposed to be equitable. So And so we can see from that poll, you know, the legal and contractual elements are one thing. We all know that that's important, but you know, coming out at the majority of the issues there are demonstrating the impact and creating commercial solutions, which is what I think everybody's going to be interested in that. So I'll pass that baton back to you, Carl.
Okay, thank you. Okay, so I appreciate we're coming close to the time where we want to be doing some questions. So John, maybe could you round up with some specific key points then perhaps people need to remember at this time?
Yeah, I think that it's going on from where Karen was. Those are the key things that we need to be doing or avoiding. Again, I go back to the point that each party under the contract needs to take their own responsibilities as far as force majeure is concerned and deal with it and not avoid the situation. I think when it comes to getting the extension of time will be one thing, and that is in theory it's straightforward, but it will be quite difficult, as I mentioned earlier, to prove. But the money side will be, as Karen was saying, it's about a fairness, it's about finding an equitable solution. And I just want to emphasize what she was saying about being straightforward. Authenticity and transparency are going to be really important. Having honest discussions about this. And what it really means is the parties to the contract actually collaborating together to find a solution for the benefit of the project. And there may be some resistance to that from the start, but unless you can get the parties to the contract actually talking about the real issues and the bigger picture, it's not going to work. Because just arguing about force majeure from a contractual viewpoint isn't going to take anybody anywhere in reality. Yes, it may solve some time issues, but that isn't going to be the end of the story. It's the bigger problem. I think that those are the issues. Get a case on the table that you can discuss, approach it on the basis of adult conversations between you and the contracting party, and be looking for and be creative with solutions that will work for the parties involved.
Okay, John.
You may have a supply chain as well to deal with.
Okay, John, what I'd like to do now, and hopefully we can bring Nicholas Bartz QC in from Atkin Chambers to perhaps, if you could, Nicholas, are you there? Can you hear me?
Yes, I hope you can hear me.
Hi, Nicholas. Great to that you can join us. What I'd like to do, Nicholas, is just bounce that question back to you about specific key points that people need to remember at this time. But I want that legal perspective, if you could just share that with us.
Yes, certainly. Thanks. I've really got 5 things to say, and they pick up on things that have been said already. First of all, I think the 77% in the survey who thought that the epidemic was force majeure are supported by the most detailed case, which is in the 1920s, which, as Karen said, based the definition upon French law. And the relevant sentence is that force majeure is used with reference to all circumstances independent of the will of man, and which is not in his power to control, and such force majeure is sufficient to justify the non-execution of the contract. Thus, war, inundation, and epidemics are cases of force majeure. So there's a good start there, but that case also makes the point very strongly that it really depends upon the contract you're looking at and close attention to the words. But there are 2 subsidiary points about force majeure, and again, picking up on the survey, that 46% of the respondents were interested in the analysis of cause and effect. It's a very important point about causation, because if you were going to be late anyway as a contractor, and that's concurrent with the events which constitute your force majeure, then you have an issue to deal with. And that really draws upon John and Karen's point about details, because there's a case recently in the Court of Appeal about a charterer delivering iron ore, where there was an exclusion or exemption clause relating to an accident in the mine. And there was an accident in the mine, but the Court of Appeal held that because the shippers would have been late anyway, they were liable for the full amount of the claim against them for failure to deliver the iron ore. And the message you get from that is precisely the message John and Karen were emphasizing, that you haven't done a home run just because you've established force majeure. You have to go the extra mile and deal with the causation issue on top of that. And the other 2 points I was going to make is in relation to one could look at this different ways. Okay, supposing we're not really talking about force majeure, are there other routes? There is the frustration route, and there's a very useful comprehensive description of frustration in a case called Canary Wharf of last year. I don't think that's a whole separate topic. But the other thought that really I'm indebted to Andrew Goddard, QC of Atkins Chambers, is also on the call, which is think about changing the law. The government hasn't yet passed laws which actually prescribe work on construction sites. But if they've passed a law which has that effect, then you may be able to bring yourselves within a change in the law clause in a contract. So those are just the points I was going to briefly make. I should mention that there's, I think, a useful summary on the Atkins Chambers website as of the 24th of March, which deals with coronavirus and force majeure. And that's been written by Andrew and Misha Balin, and is a very good background summary of where we are. Very good.
Yeah, we were going to post the link to that, Nick, on our, because we also read that and found that the views were very coincidental with ours, and we certainly the points that Andrew was making really resonated with us as well.
Yeah, good.
Nicholas, if I can ask you just to stay on the line, just in case we've got some questions here that perhaps might get side passed your way, so to speak. So I've got one sent through to me at the moment, and John, I think I'm going to send this to you if that's okay. So so it's an anonymous one, so here we go. What about lawyers saying that it is not force majeure unless you demonstrate that 1, it has affected you, and that 2, you have taken all reasonable measurements? Who determines what is reasonable measure given the circumstances? And then in brackets it says, I remind that we need to comply with all applicable laws. So if you could, please.
Well, I think, Nicholas, if you deal with this from a legal point of view, and I'd like to come back from a practical point of view.
Yeah, well, I think that the point about applicable laws is really picking up one of the points I was making, and I think we're all going to have to scrutinise exactly what the laws which the government has been passing in the last 2 weeks require, and what they make lawful and what they make unlawful. And that's probably at the moment an unexamined area for obvious reasons, that it's only just come out. But yeah, I think that the question is right, that there will be an analysis of exactly what the causal chain is. And you can expect that if, for example, you're an employer, that you'd be scrutinising that sort of issue fairly carefully.
Yeah, I think also from a practical point of view, we've seen some questions just recently as to, you know, if there's a decree somewhere, is that a change in the law? Well, of course, I think the question is the decree actually using an existing law and simply just applying it, or is it actually introducing a new law? And then once you've established whether it is a change in the law, then establishing the impact of that is the same problem that you've got whether it's force majeure or any other issue. How's it affecting time? How's it affecting costs? And therefore, go back to what Karen said earlier about records. about detailing and about being able to demonstrate what's actually happening on the job. So that applies regardless of the legal contractual situation. If we don't have records, we don't go anywhere. And I'd just like to add a point. Someone earlier had raised a question over mitigation and obligations in the contract regarding the contractor shall mitigate the effect, etc., that I think we're all familiar with, and was then going on to talk about, well, we're going to have to spend a lot of money. And there seems to me there to be a misunderstanding about what mitigation means in these circumstances, and that really it is about not making situations worse without spending your own cash doing it. What's your view on that, Nicholas?
Well, yes, I think you're right that most of the contracts do have a mitigation requirement, which is likely to be relevant. And if you think about that, that's going to get very, very granular, isn't it? Because people are going to be looking at, well, what could you have done to mitigate in more detail?
I mean, we've had questions, for example, like, you know, under my contract, I'm still required to provide offices, accommodation services for my client, you know, even though the site shut down, etc., etc. And should my cash? This is one of the key issues for, and particularly if you look at the situation with many of the contractors in the world, they're not exactly cash rich at the moment. Many of them are really struggling at the moment. So any expenditure of unnecessary cash is a key issue. And whilst that may conflict with your supposed requirement to continue prosecution of the contract where you can and your obligations to mitigate, so this preservation of cash is a key issue to be able to have the contractors and the subcontractors available to finish the jobs when we get through the other side of this, you know, without them having gone bankrupt, you know. And we've seen enough of them having gone through that situation before this situation.
I just want to come back in again, guys, if I may. We're getting some really good questions coming through, and there's one which has just alerted my eye to it, which I think would be worth answering. So maybe then, Karen, if I push this to you, please. Will the signature of a contract by two parties, given the current circumstances, trigger a force majeure event linked to COVID-19, or, don't give the answer away, John, or the signature of the contract knowing the current conditions? Will that mean that the parties know and accept the pandemic situation and then waive their rights on this force majeure event? Thanks.
Don't sign any contracts at the moment. Preferably don't sign them, but if you are signing them, make sure there is a clause in there, preferably reviewed by your lawyers or somebody like Atkins, to make sure that you have some of this covered. What we know at the moment is the key test of force majeure is foreseeability, and at the moment you cannot argue that this pandemic is unforeseeable. We've had lots of interesting questions about what happened, you know, is this one event or is it multiple events? What happens if the virus mutates and comes back round again next winter? So this is complicated, but please don't sign any contracts at the moment until you have got, without having absolutely clear legal advice on it.
Okay, I think we've got just enough time for one more question, and this is either to John or Nicholas, I think. If there is a new law made to deal with certain impacts of coronavirus, is it possible to use the change in law clause for such specific new law, although the parties agree that in general coronavirus impacts fall under force majeure?
Wow.
Nicholas, I think that's a very good legal question.
First of all, I'll give you the classic lawyer's answer, which it all depends upon the particular context. That also happens to be the right answer. But beyond that, I think the answer to that is probably no, that these are not mutually exclusive clauses. They could be used as alternatives. But that all comes out of the initial qualification. One interesting issue which may be explored in the future is whether or not, when it talks about change of law, is it referring only to UK law? What if you have a French supplier who's prohibited from supplying by French law. Does that come within your change of law clause? So, in other words, unfortunately, the issues one can see can potentially at least multiply. But the answer to the question, I think, that I'd give at the moment is, without seeing the contract and subject to that, I don't see why there wouldn't be cumulative or alternative remedies rather than substitution.
Thank you. Okay. Right. As usual, we're slightly out of time. Actually, we're slightly over time, which is fashionable for our industry, which is good. It just leaves it for me to say thank you to Karen and John, and thank you especially to Nicholas Bartz, QC of Atkins Chambers, for joining us here at the end. And we hope that you found this webinar useful, and some of you may have been to the webinar before this, and we hope you found them both useful. It is our plan to do some more free webinars based on some of the feedback and some of the questions we get from these. So please keep an eye out on our LinkedIn page for future events and possibly more collaboration with Atkins Chambers as well, we hope. So we've had some wonderful questions come through that I've seen coming through, and we haven't been able to deal with all of those. What we will be doing is I shall be sending those to Karen and John to group under key topics, and they will be addressing those. So we will be sending those out to you by email, so you feel that you've got the answers that you need. And if there are any questions beyond the scope of this webinar, then by all means feel free to reach out to myself, to Karen, or to John, and we will do our very best to deal with you, to deal with the questions just as soon as we can. That's it. Apologies for running over by just almost 2 minutes. From our team here at Kingsfield Academy, thank you very much, and we look forward to seeing you and working with you in the future. Thank you.
Thank you, everybody.
Thanks, bye.